All right, hello and welcome to my criminal law capsule. In this criminal law capsule, I'm going to go through a very basic overview of the way in which homicide is dealt with under Canadian law. And the reason I'm doing this is because it's not all that intuitive. The criminal code is based on some pretty old way of separating out different types of homicide. So I will take you through and try and show you the overview of the way the code deals with homicide so that you can really focus on what are the more difficult issues. So I think it would be helpful for you to have a criminal code with you while you went through this, but it's not obviously essential. So we're going to talk about death and the criminal code. And the criminal code essentially creates a special category for situations in which an act that you do is the cause of death. And the way it does this is through some funny definitions. So the first thing it does is in section 222, you can see right here, this is a really broad definition. So first thing it does is essentially sucks in every possible act possible and says, well, you commit homicide when you directly or indirectly cause the death of another human being. So that's a very, very broad definition. And if you think about it, you can go look at my other capsule on causation. Let's just say that, directly or indirectly cause is not a high threshold. You don't have to be the sole cause. Anything you do that causes the death of another human being is a homicide. But then right away they cut all those homicides in half. So don't be worried about the broad definition. It's just your starting point. But good starting point to think about. Anything you do that directly or indirectly causes the death, and as you'll see if you go look at the capsule on causation, that includes whether you are a partial or total cause, doesn't really matter. You have committed homicide. But then they go on to say, well, homicide is culpable or non-culpable. Great. So what that means is you can then look a little bit further here and see that essentially the code divides everything up. So it does it in two ways. Section 222 sub 2, I pointed out there, sets out there are then four types of culpable homicide. There are actually more than four. If you look at this list here, we'll go through. It's actually a little bit broader than that, but let's just say there are four categories: murder, infanticide, manslaughter, and a special category of specific acts. Non-culpable homicide is everything else. So let's start with non-culpable homicide because really, as you'll see, you'll never have to deal with it again. Let's just get it out of the way. So let's define what a non-culpable homicide is. Effectively, it's an accident. You cannot be punished for accidents. That's essentially what it is. But section 222 sub 3 makes it clear that homicide that is non-culpable is not an offense. And essentially, it's defined in reverse. I am about to go and show you the four types of culpable homicides, and everything else is non-culpable. But the easiest way for you to think about it, car accidents that lead to somebody's death, short of dangerous driving that we will, eventually look at, are not culpable. People die in accidents all the time. You will see that unless that accident amounts to some form of negligence, criminal negligence, you're still non-culpable. So you can kill someone by an act, and it can be non-culpable, obviously. In practice, what this means is that any death caused by a lawful act. And what I mean by lawful is lawful in accordance with the criminal code. You can do things that may not amount to the standard of unlawfulness that is required to warrant a criminal offense. But the easiest way to think about it, if I'm driving down a road and I hit some terrible ice and it's unforeseen and I smash into another car and a person dies, I've caused their death. I have committed a homicide in accordance with section 222 sub 1. But I will not fit into those four categories that I've showed you, and therefore we have a non-culpable homicide. Accidents obviously are not unlawful. Now, one little caveat to this. I just want to be aware, okay? Don't forget, you can still commit an unlawful act that does not cause death. And I'm not going to elaborate on that here. As I said, I've set out another capsule that goes through causation in great detail. But to give you, I'm not going to go into causation in depth, but just say, if I punch somebody and give them a light tap on the head, and then a series of events takes place in which they die, to make a long story short, I have not caused their death. You will see from the causation capsule that the chain of causation has been broken, but that doesn't mean I didn't commit an unlawful act. So therefore, I would still be guilty of the original assault. So the key is there are two words here. As you will see, any death caused by an unlawful act, when you go through all the various definitions, so you require first an unlawful act, and then you require that the unlawful act causes death. I won't go through this over and over again, but remember, I mean, the point I'm trying to make is the one set out in pink here. You can still be guilty of an unlawful act even where you don't cause death. Okay, let's move on to culpable homicide, which is much more interesting. These are defined in 4 different ways, and we will go through each of them: murder, infanticide, manslaughter, and specific acts. And let's just say that the most common by far are obviously murder and manslaughter. And you can have specific acts like criminal negligence causing death is actually very common as well. I will go through each of these. These are, again, they tend to be defined mostly in the negative, as you will see. So essentially, you start from the proposition that if you kill someone by a direct act, it could be murder. So you start from the highest. Murder is the most serious, as you will see. And therefore, if it's if it's not murder, then you move down the list and see what it might be. So let's start with murder. Murder is a very specifically defined term, and I'm not going to go through every aspect of murder, but to make a long story short, murder is essentially where you intentionally cause the death of another person. That's why it's the most serious offense. That's why it has the most serious penalty. It is defined in 3 ways, but I can tell you that Section 229A is by far the most common. And you can look at Section 229A. I'm not going to go through every aspect of murder here, but it is more or less the situation where you intend to kill somebody knowing that your act is going to kill them or is likely to kill them. And that is what most murders are. Transferred intent murder is another type of murder. It's probably, you don't even need, you can make an argument you don't need 229B because the common law, which I've dealt with in another capsule, allows for transferred intent anyway, but just for greater certainty, if I go out trying to kill A and I shoot them and B walks in front and dies, I've still committed murder even though I didn't intend to kill B. And finally, the most controversial is something called unlawful object murder, which would take a capsule on its own. Maybe I'll do one day. Is essentially another type of intentional murder, but it's a little bit different. It's not really intentional murder. It's more that you do something unlawful, knowing that that act is likely to cause death. So essentially, you're involved in a robbery, and you decide to take a gun with you, and you decide to start firing the gun. You're not really trying to kill somebody, but you know that in taking on the robbery, your act is likely to cause death in some form. And what this all means is you've committed murder if you fall into any of these 1, 2, 3 categories. The penalty for murder is life imprisonment with no possibility of parole. And then you have to further subdivide what murder actually is. By the way, before we get back to murder, murder once again creates the basic definition, and then we work essentially from the negative. So if you go back here, you've got the 3 situations. If you can't meet them, as soon as the Crown can't meet them, but you've still got a potentially unlawful homicide, right? A culpable homicide because your act killed somebody, then we work by reverse. If it doesn't fit into one of these 3 definitions, it is almost always manslaughter. It can also be infanticide, as we will deal with in a moment, but it's mostly manslaughter. So essentially, the offense of manslaughter, you will quickly find, is essentially defined in reverse. Manslaughter doesn't really have its own detailed definition. It's essentially killing where you didn't intend the person to die. That's essentially what it is. But it's still culpable because the death occurred for one of the reasons I'm about to outline. Okay, let's go back to murder. So you've now met one of these 3, whether it's A, B, or C, doesn't matter, but the Crown has managed to prove that the accused killed somebody and, let's say, did it intentionally. What does that actually mean? We have another definition. In Canada, there are 2 forms of murder. Those are first-degree murder, right here, and again, second-degree murder, which is defined in reverse. Any murder that meets these criteria, so that's why you start here. You have to prove that it's one of these 3. You meet one of these criteria. If you can't meet one of the criteria in Section 231 that I'm about to go through, you are then into second degree. So let's look at the criteria for first-degree murder. There are a number of different ways to prove first-degree murder. The most common is that the murder is planned and deliberate, and those are separate terms, and they are meant to connote the types of murder in which you have really given it some thought and planning. The idea is that all murders are bad, but murders where you really have time to think it through and take your time and plan it out and deliberate, should I do this? Those are worse. So those qualify as first-degree murder. There are also what are called special victim murders. We want to protect our police officers who are working in the course of their duty. We want to protect prison guards and a variety of other similarly situated individuals. So if you kill one of these people who are obviously working in risky situations, that is deemed to be more serious. That is a first-degree murder. A controversial one is what's called constructive first-degree murder. Essentially, we say that certain types of offending, sexual offenses, kidnapping, hijacking, criminal harassment, have a particularly troublesome qualities because they involve some form of domination of the victim. Those are deemed to be worse than the ordinary murder where you just kill somebody. I know, fine distinctions here. Finally, terrorist acts or at the direction of a criminal organization makes sense if you're doing it as an organized sort of thing and it's part of a bigger pattern of offending. That becomes first-degree murder as well. So if you meet one of these categories, it's an automatic 25 years parole ineligibility. Okay, and there's really not much to say about it. It's very straightforward. First-degree murder, that's what you're doing. And by the way, let's be clear, your punishment is still life imprisonment. If you commit a first-degree murder, any murder really, you may never get out of prison. But you will at least be eligible for parole at a certain point. That point is 25 years where you commit a first-degree murder. Any murder not first degree is second degree. It's a much different parole ineligibility period, 10 years, although parole ineligibility can be increased and often is. It's become a very, very common thing to up second-degree murders, especially where those second-degree murders just fall short of first degree for one reason or another. I've seen penalties as high as 22 years, 24 years parole ineligibility. Very common to get 12 to 15 parole ineligibility, really. The 10-year parole ineligibility tends to be reserved for, believe it or not, the best murders. It's such a hard thing to classify here, but in any event, that's where we're at with second degree and first degree murder. All right, let's talk briefly about infanticide because really it's a very special category. It comes up once in a blue moon. I'd say less than 1% of murders, it's really got to be less than 1%, qualifies, and you'll understand why. Essentially, infanticide, which is defined entirely in Section 233 of the Code, it's only for women, and it's only where women kill their newborn-ish children. That's it. It is designed for a very special purpose. Historically, what would happen in these cases is obviously you will see that a woman who qualifies for infanticide more or less meets the murder definition. It's an intentional killing. So you don't have the availability of manslaughter. And in these situations, what you're left with, as we saw, is very harsh penalties. Life imprisonment, no parole for at least 10 years. And given that these were usually planned and deliberate, or sometimes planned and deliberate murders, you could have a 25-year parole ineligibility. For a woman who killed a newborn child, and terrible thing, always terrible here, but may have done so while suffering under some sort of serious postpartum depression. Whether it's true or not, and whether those facts, met the threshold, is not really for me to talk about. But what I do know is, back in the historical context before infanticide existed, when the prosecuting attorney would charge women in these situations, the only available verdict was murder or nothing. That's all there was. There was no way to get to manslaughter. It was very difficult to get there. But what would happen was a lot of juries would refuse to convict. They would get very upset. The evidence of the woman's postpartum depression would be put before the court in one form or another, and there would be grave difficulty. So eventually what happened was Parliament, first in the UK, then in Canada, created infanticide as sort of a halfway house. And there are a lot of problems with this sort of. It's not really a defense. It's both a defense or a charge, depending on how it's raised. I know, more complications. I say it's a defense or a charge because the Crown can charge somebody right away with infanticide if the facts seem to warrant it. But if the facts are not clear to the Crown wants to go with murder, the defendant can plead infanticide effectively as a defense and say, well, yes, I killed my child, but I was suffering from the criteria set out in the section. So it's a very controversial little defense slash charge. It applies where a woman kills her newborn child. The mind has to be disturbed by the effects of childbirth or lactation. And let's just say there are a lot of flaws with the way in which the language is worded. I've explored them in other contexts. You can look up online and see what's wrong with infanticide, but since it arises so rarely, I'm just going to focus on it very briefly. Here, operates as a separate charge or defense, as I set out, and has a maximum sentence of 5 years imprisonment. So it's a big deal. If you have a case that falls into this category, obviously it's important to determine whether infanticide is on the table. But as I said, you can see just from looking at these criteria, it's pretty difficult to get into infanticide. So most of the time what you've got is murder or the alternative, manslaughter, or one of these specific acts. And this is where it gets a little bit confusing because these specific acts are not really a separate form of culpable homicide, but I have to list them because section 222(5) of the criminal code does. So I'm going to explain. This is what section 222 sub 5 actually does. First, it says a culpable homicide is where you kill someone by an unlawful act. And let me just say, to make this as easy as I can, this is what is generally known as unlawful act manslaughter. It is the most common form of manslaughter that is charged. And essentially, what I mean by that is when somebody kills somebody directly, let's say they shoot them, they tend to be charged in one of two ways. If it looks like it could be murder, the Crown will charge murder. And if the Crown cannot prove an intention to kill, manslaughter will be the result by virtue of the negative definition I showed you earlier. Remember, I said if you can't meet section 229 sub A or B or C, it becomes manslaughter. But the Crown can also charge by what's called unlawful act manslaughter, where it looks pretty clear that there was no intention to kill. In other words, 222 sub 5 is also a way to charge. By criminal negligence means nothing because there is another section called criminal negligence causing death, and that's just a way of reaffirming that where you commit a culpable homicide by criminal negligence, it is also a culpable homicide. The weird ones are C and D. And the reason I list C and D, and the only reason they're here, and let me just tell you, I'm aware of almost no I think there's one charge that I'm aware of where it's been laid under C or D. The reason is because technically these are situations in which you can kill somebody by not through an unlawful act. Okay? So essentially these are residual categories of manslaughter, although they may actually result in murder also, depending on the way takes place. You might actually meet the murder criteria by willfully frightening a child or old person. But essentially, let me give you the example. Again, you have the child who's standing on a ledge and playing around, and I walk up to them and go, ah! And the child jumps off to their death. As crazy as it might seem, it's not clear that that's an unlawful act. You go through the criminal code, and you could see that even though I killed that child, there hasn't been an unlawful act. It might amount to an assault of some sort, who knows, but let's just assume for the purposes that it doesn't, just in case this is here. And this essentially makes it an illegal act. I can't willfully frighten a child so that they die. Got it? And whether that becomes a murder or a manslaughter depends on my intent when I scared them at the window. I don't want to spend much more time on this because it almost never happens. Therefore, what we're left with primarily, if you don't have murder, what you're left with is section 222 sub 5A, which is unlawful act manslaughter. And as I said, any culpable homicide that's not murder or infanticide is manslaughter. So you're left with both the negative, because murder's been charged and can't be proven, or you can charge it on its own. It's one or the other, and it happens all the time in both ways. There's a third way. Can also occur as a result of provocation. Provocation is the only limited defense that we have, and in another capsule one day I will outline how provocation works. But for now, it can also occur as a result of provocation. So provocation that is established before the court or raises a reasonable doubt will convert murder to manslaughter. The key? The punishment is a maximum of life, but there's no minimum unless you used a firearm in the commission of the offense, and that's a big difference. So essentially, a lot of cases that involve culpable homicides are about accused persons really trying to show that they're guilty of manslaughter as opposed to murder. And of course, I'm not going through defenses here. Let me just say I'm just trying to classify the way in which these various offenses take place. But obviously, defenses like self-defense and other things are also relevant. And that essentially is your overview. If you think about it, again, this is much more complicated than it needs to be, and you'll never need to consider question 1 here again, but it's just a starting point for you. But you start here with it, whether it's culpable or non-culpable. If you understand what non-culpable homicide is, you're good here. You then move through to the various types of culpable homicide, but when you slim them all down, you're really trying to establish whether the accused is guilty of murder, and if so, whether that's first-degree murder or second-degree murder. And if they're not guilty of murder, do they satisfy the basic requirements of manslaughter, which essentially requires proof of an unlawful act that causes death. A little bit more complex than that, but I'm not going to go through all the varieties of unlawful act manslaughter right here. Really, the purpose of this capsule is to show you the way in which the code classifies the various types of homicide. In another capsule, I'm happy to go into greater depth about the way in which we distinguish murder from manslaughter. But for now, that is more than enough for this capsule. I hope this was of use to you in trying to understand the way in which the code separates the different types of homicide. In any event, have a great day.